Ready? 1, 2, 3, start. These defendants have denied the plaintiff allegations. They have denied that the plaintiff is a co-owner in possession of suit property along with defendant number 6. They have denied that the name of the plaintiff was mutated and recorded as a co-owner in the revenue records. They have denied that the plaintiff and defendant number 6 are the joint owners of the suit property. They have stated that the defendant number 6 is residing in the same village. The defendant number 6 has told the plaintiff that power of attorney was executed jointly after the receipt of entire share consideration amount for the said transactions. Hence, the plaintiff has not joined defendant number 6 as co-plaintiff. The plaintiff and defendant number 6 have jointly executed the power of attorney in favor of the defendant number 1 before the notary public. Hence, the power of attorney is binding on plaintiff and defendant number 6. The defendant number 2 is the lawful owner and in lawful possession of the suit property as per the registered sale deed dated 2/5/2011. Accordingly, the name of the defendant number 2 is mutated in the record of rights as an owner. The defendants number 1 and 2 are in the possession of the suit property along with the property RS number 90/25, which is adjoining to each other and started big factory in the year 1983 with the license from the competent authority. The defendants number 1 and 2 have put up the construction of the factory shed. The main business of the defendants number 1 and 2 is of manufacturing sugar machineries, hydraulic equipment, dam equipment, etc. since 1983 onwards till today. To run the said business, the defendants have made huge investment in construction of factory in the suit land and other lands. The defendants number 1 and 2 have maintained the sales tax, income tax, accounts. The KEB has installed the big transformer. Telephone facility is also provided to the said factory. Further, the name of the defendant number 2 is mutated in the Gram Panchayat extract pertaining to the suit property. The turnover of the defendants number 1 and 2 is more than 3 crores. The defendants number 1 and 2 are paying rupees 20 lakhs per year as a government revenue for the said factory installed in RS number 90/25 and RS number 90/25 22. In view of the additional requirement for running said business, the defendant number 1 was very much required additional space. The plaintiff offered to sell the suit property in favor of defendant as per the earlier sale agreement in which the defendant number 1 was put in possession long back by the plaintiff and defendant number 6, and accordingly the plaintiff received the sale consideration from the defendant number 1 and also executed the general power of attorney dated 23/4/2011 in favor of defendant number 1 to perform and complete the sale transaction. Said power of attorney was signed and accepted by the plaintiff before the notary public defendant number 5. The defendant number 5 had identified the plaintiff. The plaintiff and defendant number 6 have affixed their photos on the power of attorney and made endorsement and put the signatures on the said power of attorney in the presence of all the parties and the witnesses. The power of attorney was got prepared and drafted at the instance of defendant number 6 and plaintiff. So also the required stamp bond was also purchased by the plaintiff and defendant number 6. The plaintiff had authorized the defendant number 1 through execution of general power of attorney to do all acts pertaining to suit property. So also authorized to sell the property. Therefore, the execution of the power of attorney by the plaintiff and defendant number 6 is valid and in accordance with law, which is binding to the plaintiff and defendant number 6. The defendant number 6 is not at all objected in any proceeding, including execution of the said general power of attorney or sale till today. As per the general power of attorney and authorization from the plaintiff and defendant number 6, the defendant number 1 had executed the registered sale deed in favor of defendant number 2 on 2/5/2011 before the sub-registrar Belagavi. The defendants have denied the contention that the power of attorney dated 23/4/2011 is fabricated, bogus and false. They have stated that the power of attorney executed before notary public on 23/4/2011. They have denied that the photographs of the plaintiff and defendants on the alleged power of attorney are planted one. They have stated that the plaintiff has initiated criminal proceeding in the competent court of law and the defendants have appeared in the same. They have denied the sale deed in favor of the defendant number 2 executed by the defendant number 1 is illegal. They have further denied the attesting witnesses are the real estate agents and close confidential of defendant number 1. They have further denied that the attending circumstances show that the alleged GPA dated 23/4/2011 and sale deed dated 2/5/2011 clearly established unholy alliance between the defendant number 1 to 5 to dupe and defraud the plaintiff. They have denied that the defendant number 1 has created and concocted the alleged GPA dated 23/4/2012 in respect of the suit property to facilitate the creation of sale deed dated 2/5/2011 in favor of son of defendant number 1. They have further denied that the alleged sale deed is a follow-up of the concocted and illegal GPA and same is also nominal, colorable and paper transaction. They have denied that the defendant numbers 1 and 2 are non-agriculturist. Therefore, the sale deed dated 2/5/2011 in respect of agricultural land is violative of the provisions of Karnataka Land Reforms Act 1974. The defendants number 1 and 2 are born in agriculturalist family. They have further denied that the amount shown in deed of sale is inadequately low and the market price is more than the purchase value. They have further denied there was no justifiable reasons for sale of RS number 90/22. They have denied that cumulative effect of the circumstances demonstrate the colorable, nominal and paper transactions of the sale deed dated 2/5/2011. They have further denied that the defendant number 2 would not acquire any manner of right, title and interest over the agricultural land of the plaintiff. They have further denied that the plaintiff has protested for effecting the mutation entries in favor of defendant number 2. They have further denied that the plaintiff has issued the legal notice to the defendants number 1 to 4. They have stated that the suit property is not properly valued and court fee paid is improper. They have further denied that the market value at rupees 64,000 plus 1,000 totally rupees 65,000 is not correct as per section 24 clause A, clause B and 24 clause C of the KCF and SV Act. They have specifically stated that the market value of the suit property is more than rupees 65,000 and they have stated that this court has no jurisdiction to entertain the suit for this reason. They have further stated that there is no cause of action for the suit. Hence, they pray to dismiss the suit.